Do you see that same address located on 397 BBC?
I do.
Okay. And is that the is that the BP gas station?
It is.
And is that the BP gas station located at Windsor and Fulton Street?
It is.
Is that the same BP gas station that you saw in surveillance video?
It is.
Is that the same BP gas station where the car that was rented by Shannon Stillwell and Demekion Garlington is inside of is at that gas station?
It is.
Is that the same gas station where the white Ford Fusion is in, that DeMarco Boyer is in, at that same gas station?
It is.
And is that 9:59 that call comes in that for them to get on FaceTime?
It is.
And in looking at the surveillance video, is that moments before or after the red car in which Mr. Drinks was in is pulling off from that gas station? Have, and I think that's arguing.
Do you want to rephrase the question?
On the surveillance video, do you see at approximately 9:59 from the BP surveillance video that car, Mr. Drink's car, leaving the gas station?
I believe Mr. Drink's car leaves the gas station, and the other car shortly thereafter follow.
And then do they then go to, those cars go to the light that's on the FedEx surveillance video?
Yes, they stop at the light.
Now let's go to the FedEx surveillance video.
Sure.
Now, what time is on the surveillance video on the bottom? How much into the video are we at?
1 hour, 1 minute, and 32 seconds.
Is that the red car approaching the light?
It is.
Is that now the first white car, which is the white Audi, now approaching next to Mr. Drinks?
It is.
And is that the white Ford Fusion then approaching next to the white Audi?
It is.
And are those cars just all at the light currently?
Yes.
And do we now see cars moving in the opposite direction?
Yes, oncoming traffic is starting to move.
And actually, Mr. Abadi, can we go back to when the cars first get to the light? I want you to tell me, I'm investigating what time does the red car first get to the light?
1 hour, 1 minute, and 36 seconds.
What time, and tell me what time the Audi gets to the light?
At the 45-second mark.
And what time does the Fusion get to the light?
52-second mark.
What time does oncoming traffic start?
1 hour, 2 minutes, and 11 seconds.
Are they still at the light?
They are.
What time does this car that's behind pull up?
1 hour, 2 minutes, and 24 seconds.
Do you see the white Audi pull off?
I do.
What time was it?
You may have to roll it back for a
If
second.
you can pull back for a second.
You may have to go back more because it's already pulled off.
You can go back to 10211. We'll pause. Do you see the alley pulling off?
Foot comes off the brake at about 1 minute, 1 hour, 2 minutes and 21 seconds, and they pull off at 1 hour, 2 minutes and 24 seconds, or 23 seconds.
And prior to the alley pulling off, do you see the Fusion make any movement?
No.
Okay, let's go back. Can you go back to 10215?
Oh, the Fusion starts creeping up.
And what time was that?
Around like the 17 or 18-second mark.
And is the white Audi going into oncoming traffic?
Yes, it does. Incoming traffic. Oncoming traffic.
The lane that Mr. Drink's car in, is that the left turn lane?
It is.
The car that pulled up behind, does that car go left and turn left?
Yes.
And you said that you've been out to the area before.
I have.
Is the middle lane a turn lane?
No.
It's on the left lane.
Yes.
Now we can go back again to 103, 10215. Now, investigator, I want you to focus on, remember the individual you saw walking in the video before?
Yes.
I want you to focus on that individual walking.
Okay.
And when if you can show the jury when you first see the person walking.
Right there. Right, not on my screen. Oh, there it is.
And you keep playing. Do you still see the person walking?
I do.
Are they still walking when the car makes a U-turn?
It is. They are.
Can you still see them walking?
It's muffled. Yeah, they're still continuing towards the intersection on foot.
And is Mr. Drink's car still sitting in the left lane?
It is.
Do you still see the individual walking?
They surfed him right here. It's very hard to see, but you see the movement right here.
And still walking towards the light?
Correct.
On Windsor Street, where the individual is walking, what is to the right of where he's walking?
I believe I remember correctly, some bushes or shrubbery, or there may be a wall of some sort. I can't recall.
Now, we're going to have to go back again to about 102:11. Again, that were all three cars, the Fusion, the Audi, and and Mr. Drink's car all at the light.
Correct.
Now let's focus our attention on the car that pulls up. What time does the car pull up?
At about the 27 to 28 second mark at 1 hour, 2 minutes, 27 or 28 seconds.
And I actually want to pause. Mr. Abadi, are you able to zoom in that portion? And once you zoom in, you go back to 1 or 2. Thank you. Is that just a zoomed in area of the location that we just been looking at?
It is.
All right. And now I'm going to focus on the white car that pulls up. Do you see the Fusion pull for it first?
Correct.
Is that the Audi pulling off into traffic?
Correct.
Now, is the white car behind those cars?
It is.
And from here, can you tell if the car that pulls up is behind the car with Mr. Drinks?
You'll see like a gap here. It's like the tires are back towards the back of the car.
In the turning lane?
It's in the middle lane.
Keep going. And do you see the car flash on and off and the car still behind Mr. Drink's car?
Yes.
And is that light red?
It is.
And does the light turn green when he goes to make the left turn?
It is.
Following road traffic
Correct.
or following the correct signals?
Correct.
And is the car still sitting there?
It is.
At any point in time in this video, do you see any muzzle flash?
No.
But was Mr. Drink still shot inside of that vehicle?
Yes.
Now, when the Audi that Mr. Stillwell is takes off, does he go left as well?
Yes.
Right. I want to go back to 397 VVD. And I want to go all the way up to the top initially.
Okay.
This exhibit. Now, do you see the categories of the information that's contained within this exhibit?
I do.
Do you see column I?
Yes.
And what does column I say?
Speed.
All right. I want to go back to March 14, 2022. And I want to scroll to when we last looked at this document at 9:59. Was he at the location at 464 Windsor Street?
He was.
At 10 o'clock, was this at 464 Windsor Street?
He was.
That's the same BP gas station.
Correct.
All right. At 10:01, was the ankle monitor at 405 Cooper Street Southwest?
It was.
Right. And do you see that column I where it says 17 and 18?
Correct.
Right. And that's in miles per hour, right?
Correct.
When we go to 10:02, PJV2 plus VR, is that at 18 seconds? 18 miles per hour?
Yes.
And I want you to remember this PJV2 location, all right?
Okay.
The next location, 500 Northside Drive Southwest. How many miles per hour?
90.
And what time is that?
10:03.
Is that 2 minutes after the car was at the ankle monitor at the PJV2 location?
A minute.
Excuse me, a minute after the PJV2 location.
Yes.
Right. I want to show you 397 VVF.
Yes.
Mr. Sharp's going to tell you why he objected. I had already asked the witness the question about the 90 miles per hour. So that question was done. My next question, I asked her to read the location of PJV2. That's it. What was on the spreadsheet. Then that is when Mr. Sharp objected. So that is the objection that's on the floor. At this point, I've asked her to read PJV2.
She is reading off of an ankle monitor report from the ankle monitor company. To the extent that she reads off of it, that's not really my issue. It's when she starts to interpret the data. She doesn't work for that company. I don't know, for instance, the PGV2 or whatever, PJV2. I don't expect to hear her testify or what that means, because she's not the ankle monitor person. The ankle monitor person would have been the person to ask about those things. So I don't get.
So the next thing that I was going to show her, which was already admitted, is the picture of PJV2, which is a location that's already in evidence.
How does she? Okay, so
Yes. So this is the spreadsheet
Okay.
on here. I had her read earlier on the spreadsheet. The column has the name, column D has the date and time, column E and F is longitude and latitude, and column G is a location. So before the objection, I believe she was reading, or she had read, at March 14th, 2022 at 10:02 p.m., the location PJV2 plus VR, Atlanta, Georgia. That is what my question entailed. And that was
Okay,
the
and
objection.
she read that?
She
Or
read,
is, okay, she read PJV2 plus VR, Atlanta, Georgia?
I believe that.
Or is that when the objection came?
That might have been when the objection came.
Okay, and then what?
And I was just going to have her read the date and time of that location. Then I was going to show her what has been admitted already as PJV, excuse me, already admitted as 397 VVF.
That plots that location
Correct.
by the ankle monitor company? Or by whom?
We showed the ankle monitor company that picture as it correlated to this location here. So we printed out Google images of these locations, PJV2, 464 Windsor, which is what I just showed her previously.
By the latitude and longitude?
Yes.
Somebody plotted latitude and longitude on a map
No, we
to get
pulled
that
up,
location?
we pulled up the map. We went into Google and we put PJV2 plus VR. We just Googled it. And we pulled up the location.
So essentially, they want someone who doesn't work for the ankle monitor. And mind you, the ankle monitor company person's already here. They want someone who doesn't work for the ankle monitor company to take something that's on the ankle monitor company's Excel sheet and then compare it to a Google printout that the prosecutors printed out.
That is already in evidence?
That's
You're right,
already
it's in evidence. It's not. We're not admitting it through her. It's in evidence. The ankle monitor witness introduced it. He
Okay.
introduced it along with the record
Mm-hmm.
of the pictures. And so
Okay.
at this point, when Mr. Shar has
Okay, and
challenged,
then what? So you'll then say, and here's this other piece of evidence that is a plot of PJV2 plus VR.
Is that the location at the light that for the surveillance video that we just observed? Because all of this is in this is all in response to Mr. Shard's cross-examination about what occurred at the light.
Can you put that back up again, please? The thing that was just up. And from this, you are going to have her extrapolate that because at 10:02, his ankle monitor showed him at that location, then what? Because you came up here and were saying this is going to be able to show that the timeline is accurate across all the different devices. How is it going to do
So
that?
the challenge that Mr. Shard made is that the 9:59 phone calls. This started with the phone call at 9:59, which is the wiretap phone call. Mr. Shard asked investigator Rico, "Are you able to know if that is the accurate time?" Because of that line of cross-examination, we are now showing investigator Rico other admitted evidence that shows a correlation to that 59 time. So when you look at this chart, before we get to the 10:02, which is at PJB2, at 9:59, the
Please
ankle.
put that exhibit back up. Or hand it to me. I'm happy to have a paper copy of it. So now we're talking about 9:59 and not 10:02.
We're showing Mr. Shard started off at 9:59. Then, if you can recall, he went through the entirety of the surveillance video at the FedEx. So that's after 9:59. So what we are showing is other evidence that
he does not dispute that he was at the light
he disputes
at the same time as Mr. Drinks was.
Your Honor, he disputes that Mr. Stillwell is the person who was shooting. He disputes that the call at 9:59 was a call to get on FaceTime to shoot Mr. Drinks. We are saying that call, that FaceTime call, is a call where they said we are getting ready to go shoot the ops. That's why they get on FaceTime. So he is challenging all of that, Your Honor. So what we are showing is at 9:59, if you look here on the ankle monitor, he's at 464 Windsor Street. That is the BP gas station. He then a minute
9:59 is accurate. And lined up to, I mean, I don't see how you can establish that 9:59, according to the ankle monitor company, is spot on to the second. 9:59 according to the wiretap.
But we're saying that it's accurate time, Your Honor, because he's at 464 Windsor, which is where, if you look at the BP gas station video footage, that is when all the cars begin to pull off from the surveillance video at the BP gas station.
But there is no cross-reference to the wiretap, which is the point. That's my only point. It's 9:59 on the wiretap. We don't know when it is on the rest of these devices, and this information does not give us for other surveillance systems.
Agreed.
And
Do you have him on the video at the BP station talking on the phone and going like this?
We have the wiretap that has him. We believe the phone plot.
I know you believe it. Do you have evidence to establish it?
Our evidence is circumstantial evidence that he is at the gas station. Do we have direct evidence?
No. Do you have evidence that the 9:59 that you want is the same 9:59 on all of the different things that recorded time in video?
That is why we're showing this, Your Honor, because we're trying to show circumstantially that all these times are.
How are you showing circumstantially that it lines up?
Your Honor, because when we look at the ankle monitor information, he is at the 464 Windsor at 9:59. The call comes in at 9:59. The BP gas station surveillance video has 9:59. So we are showing that all of these things coexist. So the time cannot just be off because all of the times are at approximately 9.
That's if he got the call when he was still at the gas station.
Your Honor.
The fact that they at some point say 9:59 doesn't establish anything if you don't have a video that shows him talking on the phone at 9:59, so that you can go, aha, see, the video lines up with the ankle monitor that says 464 Windsor Street. Otherwise, it's just what you want it to say, but it doesn't actually, even circumstantially, establish that. You can argue it, but you can't have a witness say, yep, this says 9:59, so that means
But we
that's
didn't
when that.
ask her to say that. Your Honor, we never asked Investigator Rico to say that. We asked
I
her
know,
what
but
time
you were telling me that's what you were
No,
leading up to having her say.
No, it's not, Your Honor. What I said, and I would never have her say, is he exactly on the phone at that time, because he's in a tinted car, so we don't know. What we know is from the wiretap that at 9:59 there's a phone call. That's what we know.
At 9:59, according to however the wiretap clock was running.
Correct.
Yes,
So
nobody disputes that.
Your Honor, we've stopped talking about
You
9:59.
came up here and said, I'm asking these questions so that I can establish that the timeline lines up for everything.
Yes, Your Honor, the timeline lines up. So at this point, I can show that all of these different devices are around approximately the same time.
I don't think anybody disputes even that it's approximately the same time.
Mr. Shard does.
You can have her, it's in evidence. You can have her read something, but you cannot have her say, yeah, that means all of these times lined up.
I
That
never was
means
gonna
9:59 here and 9:59 on the wiretap were the same thing.
We never had her. We were finished with the 9:59, Your Honor. The only thing I had just asked her was about PJB2 when he objected. We were finished with 9:59 about 5 questions ago. So the only thing that Mr. Shard objected to at this time was that she was reading PJB2.
No,
That's
that
what the
she was
objection.
about to interpret.
She was not, and that's the thing.
Okay, well, great. She's not going to.
Okay, well,
That wasn't the state's intention.
Okay, and I have no idea why you think any of this is going to establish that all of the times lined up. But
I'm gonna get on relevance grounds at this point, because I don't know where we're going, but it seems that they were trying to establish something. They said they're done establishing that, and Investigator Viverito is still interpreting ankle monitor data. So I'm gonna object to relevance for it.
Your Honor, as I stated earlier, Mr. Shard has challenged what occurred at the light. So at this point, we're just showing, based on admitted evidence, what occurred at the light. That's all.
Can I ask a question? Why is it improper or not relevant? So if there's been questions and testimony about whether the times for everything sync up, I think it's been Mr. Sharp's, he's arguing the entire time. Well, in the screenshot that was in Detective Hogan.
Okay, I didn't rule that it wasn't relevant. What we discussed up here at the bench was scope of redirect, which is when Ms. Hilton said, oh, yes, it is, because I'm going to be establishing that all of the times line up.
He, on cross, he disputed that the 959 from wiretap was anywhere close or could be related to the 959 anywhere else.
Was established as being the same 959, and I have heard nothing that, maybe you could tell me how you can establish that.
So at 9:59, when he makes the FaceTime or the call, he is at 464 Windsor Street. Okay, so then you go to your next step.
No, that is, how do we know that he's at 464 Windsor Street?
Says it.
Because some other item of evidence says it, and we don't know that they're all running on the same clock.
That's what we're trying to show you it is, because at 9:59, if everyone would just wait, and we'll get to the big ta-da. So if at 9:59 on the wire, it says 464 Windsor Street, on the ankle monitor, on a separate device, at 9:59, Mr. Jackson is at 464 Windsor Street. That correlates, they're the exact same place at the exact same time. At 10:02, it shows that he's at PJBR2, whatever. That's the intersection of I-20 and the light. And then at 10:02, on the FedEx thing, it says 10:02, 17. So it's the exact same thing. It's just
you want to have her say, but Ms. Hilton says she'll already left 9:59 anyway. So I still at a loss as to where we are. But we'll just get her back in. And
I have a motion before the jury comes out and bring it back in because unfortunately it's my job to ask the patients.
what's that?
Yeah, I have a motion to strike the testimony of Investigator Viverito as well as any evidence that came under her. And the reason I make this motion, Your Honor, is yesterday it came up that she had not been, that she had been following the case. The court asked me to not
No,
pursue that. I'm not.
Come up that she had been following the case. It came up that she knew that somebody had mentioned her on Twitter.
Okay, and your opinion would have been different if she was following the case? Because,
No, if you know that she was following the case, that doesn't exclude her as a witness. You can let the jury know that.
okay, because
You can ask her that.
I can ask her about her following the case?
Sure, and we'll see what she says.
Okay,
And if that's so, then it still doesn't exclude her testimony. It just lets the jury know, well, she may know some of this other stuff from listening to some other witness.
okay, because what I would like to get into, and we may as well bring it up now before the jury is here, is that she got into an altercation out in the hallway with Kayla Bumpus.
Why is that relevant to the guilt or innocence? of
I'm about to go there, Your Honor.
Okay.
Just let me finish a second. She got into it because she was watching Kayla Bumpus's YouTube feed about this case, and Kayla Bumpus apparently called her.
Okay, you may get into whether she has been tracking this case.
Mm-hmm.
You may not get into whether she got into a dispute with somebody
gets into
about their posts.
It gets into her bias against these defendants, Your Honor. It goes directly to it.
What are you proposing to ask?
I'm proposing to ask if she told Kayla Bumpus in the hallway that was the last time she was going to call her a hoe. It goes direct.
I'm sorry, the last time who was going to
Sorry for the pronouns, that Kayla Bumpus was going to call Investigator Viverito.
We need to get into who it was, or just that somebody.
I think we need to get into who it was.
Why?
Because she's married to Mr. Jackson.
Well, was she at the time? Is this for real, y'all?
Yeah. Well,
None of this is relevant. Whatever is happening between Ms. Bumpus, Mr. Jackson, has nothing to do with the guilt or innocence.
If she is-
Unfortunately, the bias of a witness. Well, fortunately, or I strike that. It is not fortunate or unfortunate, except for the fact that it is dragging this case on even longer. But a witness's bias towards a party may always be shown.
If she is in a dispute,
Not talk at the same time.
Kayla Bumpus is not a party to this incident. Kayla.
Yes, but if she's married to one of the parties, then that might qualify.
I don't know. I'm not the proponent of this evidence. I'm hearing Mr. Weinstein out, but my silence should not be viewed as acquiescence that I believe this should be admitted. I need to hear what Ms. Weinstein's saying because I may have an objection myself.
What I'm saying is that if there is a relationship between Miss Bumpus and the defendant, then Investigator Viverito's bias against that.
Being called a bad name?
No, if she is in an altercation with someone that's in a relationship with the defendant, I think, and especially if it is a threat, because
How is that a threat?
that's the last time you're going to call me a hoe. I mean, I've had clients arrested for less.
You may ask.
Thank you, Your Honor.
No, I'm not finished with my sentence. You may ask if she is following the case and has been following the case in any kind of manner. But it's really only relevant if she listened to the testimony of a witness. So you could ask that. But if she's just looking at, and I don't even know if she was looking at, maybe somebody told her. So why don't we get her in here and find all of that out outside the presence of the jury before we go into something that ends up being a bunch of nothing?
Well, that's why I wanted to bring it up when the jury wasn't here, Your Honor.
So can we also bring up before we go into the side searches, the fact that Ms. Bumpus represented Mr. Copa,
mean, I don't think saying who this is before we find out anything, I mean, do we know whether, we don't even know whether she's actually married to him or if she was married to him at the time or if Miss Viverito knows that or if it was because of any kind of bias against Mr. Stillwell or just that she doesn't like being called that name.
Well, and no one would, Your Honor, obviously. But if she is in an altercation with someone in a
What do
relationship,
you mean by altercation?
a verbal altercation,
Okay. I mean,
You know,
a
if there's-
verbal, that's
if
the
they're
last
idle-
time you're gonna call me that?
excuse me, I'm sorry.
That's the last time you're gonna call me that? That's not exactly an altercation. Is that all you got?
That's all I have.
Okay, that's it. I think that this is 403 material.
Hoisted on my own petard, Your Honor.
Correct. All right, let's get the witness back in and the jury back in.
Thank you, Your Honor. I'm going to publish now 397 BVF. And looking at 397 BVF, do you see that same PJV2 plus VR location that you saw on the spreadsheet?
I do.
And are you able to tell where that intersection is?
I am.
Where is that?
At Windsor, looks like just north of Rawson or at Rawson.
Yeah. On cross, do you recall when Mr. Shard asked you about the handgun that was on the table at 2830 Waters Road?
I do.
And he asked you about three types of guns: Springfield, 6 Hour, and Smith and Wesson.
Yes.
First, let me ask you: Do you know if a Springfield makes a 40 caliber weapon?
They do.
Do you know if a 6 hour makes a 40 caliber weapon?
They do.
And do you know if a Smith and Wesson makes a 40 caliber weapon?
They do.
Permission to approach the line?
You may.
I'm going to show you what's been marked as stated in 531 VV, 532 VV, and 533 VV for demonstrative purposes only. Tell me if you recognize those types of weapons in 531, 532, and 533 VV.
One is a Springfield XD firearm, one's a 6 hour Peak 229, and one's a Smith and Wesson.
And looking at those three weapons, are they able to illustrate what you were talking about, the distinction between the Glock 27 as well as these other types of weapons?
Yes.
Your Honor, this time the state would like to enter 531 VV, 532 VV, and 533 VV for demonstrative purposes.
Admitted.
Permission to publish?
You may.
Looking at 531 VV, are you able to tell the jury about the distinction you were making between the grip of, let's say, a Springfield versus the Glock that you were talking about on the table at 2830 Waters Road?
Yes. We along the bottom part of the grip.
Say it one more time.
Along the bottom part of the grip. See, right. You have to scroll it up for the jury.
Or can you use the one at the...
Or, I'm sorry. Right here. This is straight across. Like with a little bit of a piece that comes down towards the back.
And is that distinguishable from what you were describing with the Glock?
Yes.
All right. Now looking at 532 VV.
Again, the same thing. You'll see there's something that comes down to the back, but otherwise it's higher up towards the front.
And you have to speak into the mic for me because I can't hear you.
Sorry, it's lower towards the back, higher up towards the front. So kind of a part that dips down the back and then comes up.
And for 533, sorry, what kind of gun is this 532 BB?
I believe that's the Springfield XD.
Or 532?
I'm sorry, which one? 532? It's a 6 hour P229.
And then 533 BB.
You'll see again here, there's a piece in the back, but then once you get to the front, it's just straight across.
And then what type of weapon is 533 BB?
That would be the Smith and Wesson. I'm sorry, the 530. Yeah, Smith and Wesson.
Now I want to go to, and Mr. Kokomo, if you can help me out, please. DS57A, DS57C, and DS58A. And while that's being pulled up, Mr. Shard, they asked you whether or not there were people, I guess, not to say looking for Mr. Stillwell, but that there'd be some concerns for his safety because of the Tierra Jones killing. Do you remember a line of questioning regarding Tierra Jones?
Yes, several years ago, it was an incident.
When was the Tierra Jones killing?
It was several years ago. I can't remember the exact date.
Do you remember the year?
Not offhand.
Now, looking at, I believe this is DS57A. Is this the communication between Mr. Stillwell and Miss Alexander regarding the shooting at McDaniel?
It is.
I-20 and McDaniel.
It is.
Do you see any response from Mr. Stillwell in the text message that's, dang, babe, I was just at that intersection? man, glad it wasn't me. I just missed being at that location.
I do not.
Do you see any text messages to Miss Alexander that says, man, I was just at that BP gas station a little while ago. That's up the street from there.
No.
I want to go to DS 58. And is that the communication between Mr. Stillwell and his grandma?
It is.
Do you see where she says, hope you're not near Windsor Street shooting on the news? And says, answer me, please.
Yes.
Does he say anything to his grandma? I'm like, no, what, grandma? I was over there earlier, but it's not me.
It is not.
Now, we talked about searching for on Fox 5. Do you remember talking about the searches on Fox 5?
Yes.
Okay. Did you see any searches on March 14th when both his grandmother and Taisha were asking him about whether or not he was around that location or if he heard about it? Did you see any searches for the shooting on that day, on March 14th or the early morning hours of March 15th?
No.
Are all of the searches on March 17th?
They are.
And is that the day he was ultimately arrested for these charges?
Yes.
Now I want to go to Stacey Exhibit 437 VV, page 2145. April 1st, 2022, from 11 p.m. 11 minutes to 11:20 seconds into that call. 11 to 11:20.
Yeah.
That's all it is, just assume.
Yeah, I already know, like, when they got down, go to wiping down, doing them got down, them, you know, they gunpowder, forensics, all this shit up.
Yeah.
Gonna come back clean, you see what I'm saying? So I ain't tripping on that.
Uh-huh.
Yeah.
During that call, he says when they talk about that GSR stuff, it's going when they wipe it down, it's gonna come back clean.
Correct.
And at any point they say, I don't know I don't even know what any of this is about.
No.
Does he say to his best friend, I don't even know why they took this?
Sustained.
Does he say to Demekian Garner on this call, I don't even know why they took that car?
No.
Does he say to Demikion earlier in the call, that Miles and Quay, they don't need to worry.
Yes.
Miles and Quay, were they both in a Ford Fusion?
Yes.
Were they in the car that was furthest from Mr. Drinks?
Yes.
Did you hear when Mr. Stillwell told Mr. Garlington, I told them not to talk to the police, don't say nothing? Did you hear what he told Mr. Garlington that?
Yes.
And this entire call is on the contraband phone
Correct.
that can't be monitored,
Correct.
or outside of it being a wiretap, cannot be monitored.
Correct.
LPR readers, what information do you need about a car in order to look for a car on an LPR reader?
A license plate, a tag number.
Do you even know the make and model of a car?
Overruled.
You can try by make and model, but it's not very accurate sometimes, especially at night.
With the two cars that we saw in the FedEx surveillance video, were you able to see any license plate information on either of those two cars in the FedEx video?
I was not.
And at that FedEx video, is that where we see the Audi and the Ford Fusion run the red light?
Yes.
Of course, no.
All right, Great Cross.
Thank you, Your Honor. It's court. Investigator Viverito, good afternoon.
Afternoon.
So, you were just asked about LPR readers, and I think the context is figuring out the car that did the U-turn and the car that sped up behind Mr. Stillwell.
Okay.
And you said you need a license plate, and that you can't see the license plate from that video.
Or if you haven't, sometimes a make and model search might work, but at night, in my experience, it's not very accurate.
Well, are you aware that it was in fact a make and model search that night that revealed the license plate of the white Audi and the white Ford Fusion?
No.
Okay. That Detective Ender, I believe the name is, did? Okay. So, bottom line is, LPR search by make and model, it's never going to work if you don't try, is it?
No, but if you're saying she did it for those two, it probably should have captured whatever other car.
Okay, I agree. All right, so what's the license plate of the car that sped up behind Mr. Stillwell?
But I was going to continue. Like over the summer, I've been working an investigation quite extensively, looking for a very particular two cars in the city. I probably have searched every LPR in the city by make and model. And at night, you may put white Nissan, you may put white this, white that, and I'm getting back white Tesla. When I look at the license plate and pull up the results, they're not correct.
I appreciate that anecdotal story about what you've been doing this summer, but the fact is, that night, make and model was used to reveal the license plate of the Ford Fusion and the white Audi.
Right,
And it was nighttime on March 14th, correct?
right. But depending on what LPRs those cars had hit, that location on Windsor right there, I don't know if there's one right there that would have caught it clear enough.
Okay, well, what LPRs did the car that sped up behind Mr. Stillwell that has not been tested for gunshot residue? What LPRs did that hit?
You'd have to ask Detective Hogan.
Okay, you keep saying ask Detective Hogan. One minute side of Windsor Street trying to find homeless people as part of this case,
Correct.
and the next minute you don't know anything about the case, Ms. Detective Hope.
That's not what I said.
Okay. Well, I want to know, do you know if any LPRs were run on the make and model of any cars besides the white Audi, the Ford Fusion, and the red Versa? Do you know if any other LPRs were run, or even attempted to be run?
First, I wasn't in charge of running the LPRs for the case, and if they were running it by make and model, that maybe they saw. If you have a make and model, it's much easier than just say not having one that you're looking for.
You talked about the phone conversation between Mr. Stillwell and Mr. Garlington about he never told Mr. Garlington, I don't know why I'm being arrested or something to that effect, or I don't understand. Okay, when people are arrested, you've arrested people before, right?
Correct.
Okay, and you typically tell them what the charges are. You give them that courtesy.
Yes, of course.
You tell them what you're arresting them for.
Of course.
Okay, they don't have to agree with you, but you do inform them.
Correct.
Okay, so are you saying that Mr. Garlington is the first person that Mr. Stillwell would have talked to after being arrested on that phone call or that phone conversation? Right? Is that what you're saying?
No, he'd been in custody for a minute at that
Okay,
point.
and you would agree that there's probably been significant ability for the people that arrested him, other people involved with this case, to inform him what his charges are and generally what he's accused of.
I don't think that's a Miss Hilton. That's not how I took the question for me.
Okay. Cool. We pulled out this mapping information for the call on March 15th at 2 a.m.
Correct.
And it showed that, remember that radius? It was Mechanicsville.
Correct.
Mechanicsville is in fact in the city of Atlanta, correct?
Correct.
It's in the city.
Correct.
And finally, just one other thing I wanted to ask you about. This night, could you do me a huge favor? I think it's 471. Could you publish? This is 471 VV, and that is a picture of Mr. Nichols, correct?
Correct.
And on it says, on the picture on the right, it says, what you saying, I run with cold-blooded killers, bloody killers.
Correct.
Okay. Now, I'm not an Instagram person.
Okay.
Those words, are those words that Mr. Nichols typed into this photo?
No, I stated that yesterday.
Okay, well, we're gonna go through the whole process.
Okay.
So these words are when you pick a song such as Young Boy Never Broke Again, Villain, and someone clicks on the post, the music plays, correct?
Yes.
Okay, and as the music plays, lyrics come up.
Correct. You select a portion of the song that you would like to play.
Well, that's not entirely true. Instagram suggests a portion.
It's like between a 10 and 30-second portion.
Yeah, and Instagram
You can
suggests.
You can agree with it or you can modify it.
Right, but Instagram suggests.
Correct.
Okay, so if I'm posting something and I want Young Boy Never Broke Again, Villain, I'm going to post, I'm going to say that's the song I want, and Instagram makes a suggestion.
Correct.
Okay. And now I want to go to the video. Thank you, Ms. Knight. 471 VVA. Miss Knight's about to publish it, what I would like to do, and I know we've seen it already, but if you would indulge me, tell me when the screenshot that you took and provided in discovery for 471 DB, tell me when that comes up.
With the case, but it's my understanding that we had to condense the social media, so that was the screenshot that was turned over in lieu of the video.
I'm going to ask that question again. To get that screenshot, you had to parse this to a millisecond to get those words up on the screen.
Or I just took a screenshot and it happened to be that one and we kept it.
Just happened to be that one.
There are other things that probably would have been better to keep.
Okay.
That weren't kept.
So you just happened to screenshot. Now you would agree that in this video, Mr. Nichols and these lyrics are being shown on the screen as it's being played.
Yes.
And you would agree that many of the lyrics, as the song is being played, are up on the screen and easy to read.
Correct.
Okay. And right before the lyrics become easy to read, there is a split second, a millisecond, that has 471 BB, isn't that correct?
Correct.
You don't even know if those lyrics were the ones, first of all, you don't know if it was just suggested by Instagram or actually chosen by Mr. Nichols, right?
The song was chosen by Mr.
Yeah,
Nichols.
of course the song. I'm
Okay.
talking about the lyrics. You don't know if it was Instagram choosing these lyrics because these are the most popular ones in the song and they make a suggestion.
No, but based on the rest of the videos on the post, the theme is murder, bullets, guns, things like that. It fit.
So again, and you don't even know when it's on for that millisecond. Just supposing, hypothetically, if Mr. Nichols did choose the lyrics, you don't even know if that was Instagram just had the last lyrics up and then was giving to the lyrics he chose, which are shown clearly, or if it's something that Instagram just chose. You don't know.
I don't, but he can preview the post before it posts to his account.
Okay. So you have absolutely no evidence that Mr. Nichols intentionally chose those lyrics.
Which is why I included the video in its entirety with the other posts about murder and shooting.
And in preparation of this case, you scoured this video and paused it at that exact millisecond when it had those lyrics.
Did not. Took a screenshot.
Okay, took a screenshot. I'm sorry. At that exact millisecond where it had those lyrics that are in
I-
471.
I probably took several, trying to catch all the lyrics, and that was probably when we had to condense evidence. That's one that was chosen.
How many different screenshots did you take?
I have no idea.
Well,
We're
can
talking
you
about
just tell me from your report?
I can't. You can look at my folder that was served to Discovery and tell me.
All right, thank you.
You're welcome.
Ms. Weinstein, anything? Okay.
Good afternoon, Investigator Viverito.
Afternoon.
So you mentioned that Mr. Kendrick's phone was seized at the time that he was arrested on May 9th, 2022, correct?
It was.
And his phone was extracted.
It was.
Did you review that extraction?
I did.
And if you reviewed that extraction, did you see that he had been spending several months in LA and had only returned to Atlanta within a day or two of the day he was arrested?
I did.
Did you also see other location data within that phone?
Absolutely.
Okay. And in that location data, again, he'd been spending the bulk of his time in California, correct?
Correct.
All right. Did you look through all the photographs on that phone?
I looked through a good bit of them, yes.
The two photographs that were shown in court this afternoon, are those the only two photographs of interest that you believe were in the phone?
No, there was probably a few.
Okay. Did you find any evidence on that phone that Mr. Kendrick was in possession of any firearms?
No.
Okay. Let's briefly return to the Richard Mill watch.
Sure.
I understand the eye roll. During the seizure that day, and I'm looking at a property report.
Sure.
During the seizure that day, you, and when I say you, I mean APD, can I say under your supervision, is that accurate?
I didn't work for APD at that time, so
Well,
I couldn't.
Okay, then let's just say APD. APD seized, APD seized a necklace and a pendant from a bedroom, correct?
I guess I'd have to look at the report. I don't have it in front of me.
Okay, well, you were involved in this. They seized a blue box of jewelry, correct?
Correct, in a red box.
And a red box of jewelry. They seized jewelry that was on Martinez Arnold.
I believe so.
They seized a Chevy Corvette,
Yes.
a Dodge Durango,
Yes.
a Mercedes-Benz AMG,
Yes.
a Mercedes-Benz GLS class,
Yes.
a Porsche 911,
Yes.
a Jeep Grand Cherokee,
Yes.
a pink Lamborghini,
Yes.
Another Mercedes Benz, aluminum silver,
Yes.
about jewelry that was located in a Mercedes AMG.
Yes.
And they even seized a ring found on Jeffrey Williams' hand, correct?
I'd have to see which one was on his hand. I didn't have any contact with Mr. Williams when he was arrested.
Okay. So, despite seizing all of that, you left behind the Richard Mille watch, pink with a white ceramic case.
Again, Mr. Weinstein, as it's being inventoried, the jewelry is being looked at. I use photographed. The jewelry is being put on the thing. If you watch the video, and it's placed on the shelf, and nobody messes with it again.
So, was that a yes?
Yes.
Okay, thank you. I have no further questions.
Thank you.
All right. Thank you, Detective. You are
Thank you, Your Honor.
excused. Do you have any more witnesses?
I know, but before we do, we just need to, we have about 5 minutes, so we're already in evidence.
To make sure that everything's in evidence? Sure. We'll take a short break. All right. While you are making sure that all of your stuff is in evidence, I need to ask each defendant some questions about to make sure that they understand their right to testify or not. All right, let's be back at 4:45. will both be examined by your attorney and cross-examined by one of the prosecutors. Do you understand that? All right. And do either of you need any more time to talk with your lawyers about your decision whether to testify? All right. Mr. Kendrick, do you personally want to testify or not? Okay. Mr. Stillwell, do you personally want to testify or not? All right. I find that each of these defendants has made a decision whether or not to testify with an understanding of his rights. All right. All right, we need to do anything else before we get the jury out, and I'll ask if you rest. And then have y'all made a decision about whether y'all gonna present evidence? Okay, you wanna let me know or you wanna be dramatic about it? Okay, all right. All right, then I'll get them out, we'll close the evidence, I'll let them go for today and tomorrow, have them come back on Thursday. And tomorrow, I mean, we can start the charge conference and, oh, forgot something. There'll probably be a motion, I suspect. Okay, all right, forgot about that. Okay, so I guess technically you need to rest before that motion. So I'm gonna have to bring them in, then excuse them again. Okay. Yes.
I understand that we're trying to keep things moving. I'm going to ask if Your Honor would consider giving us the afternoon and evening to look at the directed verdict motion. I know that you've suggested we need to be doing that, but there's only 24 hours in a day, and I think it would probably be more fruitful if all of us had an opportunity to review kind of what's come in, and so we can sit down and have an educated discussion.
Sure, that's fine. So tomorrow we'll gather together. You'll present whatever motions you have,
Thank you, Your Honor.
whatever response there is. I'll have to consider all of that. But I would also like to do the rest of the charge conference, the Rico part of the charge conference.
We have a further discussion there once we see.
Yeah, sure. Okay. What are you, do you need?
I was thinking procedurally, what happens, we rest,
We rest. I'd let them go for the day. All right, Ms. Hilton, does the state have any further evidence?
No, Your Honor, say the jury to rest.
All right, thank you. Okay, ladies and gentlemen, considering the hour, I think that I'm gonna let y'all go for the day. And then actually tomorrow, we will all have matters to take up outside of your presence. It's been kind of a common theme in this trial, and it happens in every trial, I promise. So y'all will have the day off tomorrow, and we'll see you back Thursday at 9 a.m. And just let me remind you all of the instructions that have been applicable to you for the entirety of this trial remain applicable right now. Don't try to find out any kind of information about this case from any source outside the confines of this courtroom. Don't talk to anybody about this case. Don't let anybody talk to you about this case or anybody involved in it. Don't try to do any research about the case. Don't ask anybody hypothetical questions about the case. And we'll see y'all on Thursday. Thank you. Okay. So what else did we want to discuss?
When we were, Your Honor, when we were talking about the Rico jury instructions, I guess what I'm trying to figure out, I understand that we have certain jury instructions, preliminary, we both submitted preliminary jury instructions. And I know that we have certain ones on that document that we're all sharing. I'm just trying to make sure, are there any other proposed instructions from the state that I need to be aware of to prepare for argument? Because I don't want it to be sprung at the last minute.
I mean, I haven't gotten any. Are there going to be any more forthcoming? I've been trying to put some together from various things that I've culled from different Rico cases. And that was pretty rough when I sent it to y'all yesterday. I've worked on it a little bit more today. So I'll send y'all an updated draft, which, Ms. Percival, let me send that to you right now. So what this is now, it will look somewhat familiar, but it's in a little bit more polished form. So the first 4 pages are what I've put together, and then the last page and a half probably is lifted, some of the language lifted from the APS, Rico, not APS Atlanta Police, APS Atlanta Public Schools cheating trial. I had looked at some other trials too and tried to pull some language from that. But if there's something else, I haven't gotten it yet. Mr. Floyd, are you going to be providing us with any suggested jury instructions on Rico and or a possible verdict form with regard to Rico, which would be really nice?
Those are separate but related questions, Your Honor. So to answer the first one, we haven't sent anybody any additional ones. We looked at yours; they didn't kind of involve me. But I don't have very much to complain about. They're largely drawn from APS, and I wrote them, so I'm not. It's only just a matter of whether there's anything in between.
Those aren't actually drawn from APS. I didn't look at the APS stuff until this afternoon, but okay, you can take credit for it.
Well, okay. I thought that's what you said. I'll tell you that they're not drawn from APS. They're drawn from cases that use a version of the APS charges.
Okay.
There might be an intermediate generation, but
Anyway, I hear you saying you think they're pretty good.
You heard me say I think they're pretty good.
Okay.
I mean, I can't at this stage because we're just starting this process.
Sure.
I can't foreclose that depending on what you decide to do with one charge, we might suggest that another needs to be supplemented or add something.
Sure.
But I think
You don't have any whole scale additions that you think need. We just hash through it. Okay.
I do not, and I think there's one issue that has to be resolved. I only have 2 charges submitted by Mr. Kendrick.
Yeah.
I don't have any charges
They're working together on it.
Okay, I'm just making sure I'm accounting for everybody here. I understood they were from the defense. They had the name Kendrick on them, so that's why I did that specification. But, I'm gonna surprise you. We disagree with them. I'll explain why. One is a short explanation, one is a longer explanation. You have statute of limitations.
Oh, yeah, I already told him he's totally wrong on half of that.
Okay,
You missed that part, but
Okay. It's the opposite. The rule is the opposite of that.
all right, well, we'll get into the nitty gritty tomorrow if that's okay with everybody.
Sure. And the other one, which is how you instruct the jury about overt acts and what conclusions they need to reach, that feeds into the jury form. And I've done a bit of research and I have some things to say about that.
Well, if you have anything for me to consider sort of in the interim, because you probably are not going to be, I mean, you might be working on the directed verdict motion and response, but if you're not, and if you have something that I could be considering in the interim, go ahead and send it to Ms. Persifield. Because, yeah, I mean, it's a lot more straightforward when you're alleging Rico and not a Rico conspiracy. And so I definitely want to get right what it is that the jury has to find. So, yeah.
So, I mean, I can tell you that what the state submitted is based significantly on EPS, which was also a Rico conspiracy case.
Mm.
It was also based significantly on the jury charges that were submitted in a federal Georgia Rico case based on sex trafficking this year.
Okay.
And also on a case that was tried last year in Brunswick that was the Georgia Rico conspiracy.
All right.
So it's sort of the evolution of that. And I'll address what you want me to address, how you want me to do.
Okay. All right. So if you do have anything more in writing, go ahead and send that now. And that includes a potential verdict form. Just send it to Ms. Persifield. She can send it out to you. I mean, I think we've got a list of all of the attorneys. So
I don't have anything set to send right
okay,
now.
that's fine.
It's night or first thing in the morning. I mean, our view is the verdict form can be very simple.
Interesting. Tell me more.
Okay, why don't I get into that then? So the question I think that has come up is whether the jury should be asked to decide which acts of racketeering activity the members of the conspiracy agreed would be committed. And there's two approaches to that. One approach, which is usually what defendants suggest, is that there's going to be a very long list of every one of them, and they're going to be asked somehow, did the conspirators, which would really mean any of the conspirators, but any two of them, agree this crime would be committed. Because the ultimate objective has to be a substantive violation of the statute. That's the Supreme Court, U.S. Supreme Court said that in Salinas, and I think you've recognized that in things you've said and pleadings that have come along. The other approach is to say, instruct them that they have to agree that the conspiracy contemplated certain types of acts of racketeering activity, and they have to decide whether the conspirators agreed that any of those types would be committed without going to specific ones. So, and usually when I've addressed this issue or something like it, the argument from my opponents is, well, why wouldn't we want to know everything? The answer is, you get a case like this where you have almost 200 overt acts. About half of them are also racketeering activity, and that is an opportunity for a lot of confusion, and it takes a lot out of the jury. It's a big ask for them, and jurors.
So we've already asked so much of them.
I suggest we ask not that much more, but that's just me. But the point is that is just not normally how it is done. And this starts out with, I know we submitted a brief on this earlier, a bench brief, but it starts out with a basic understanding of what conspiracy is. And the crime in conspiracy is the agreement. The crime is not the commission of acts of racketeering activity, because none have to be
Right,
committed.
it's the agreement plus one overt act.
Exactly. And the function of the overt act is important to understand too, because the overt act doesn't have to be a crime. And the reason is the function of the overt act, which is to show that the conspiracy is in operation. You know, I mean,
Right.
and I realize I may be telling you a couple things that you are very familiar with, but I will be very brief. I mean, common law, no requirement for overt acts at all. There's no constitutional requirement. Federal RICO doesn't require overt acts. The Georgia General Assembly decided to track 1648, which is
Right.
the general conspiracy statute in 2015 that was added. I'm actually kind of familiar with how that happened by coincidence. And that's it. We have an overt act requirement. But all that overt act does is show that the conspiracy doesn't exist solely in the minds of conspirators. It's actually moved into the real world. And there's kind of a fairness issue in that, which isn't required, but many legislatures decide to do it because it gives someone who, I'll just draw the example, you know, there's folks are having a few beers and there's a lot of talk about what ought to be done, and everybody says, yeah, that's great.
Yeah.
Nobody does anything. The next morning, someone sobers up.
Charge somebody with the crime.
Hell no. So that's how it functions. So this question has not come up under Georgia RICO. This question has come up numerous times under federal RICO.
This question being what?
Does the jury have to decide which acts of racketeering activity the conspirators agreed to commit, or is it sufficient for the jury to decide the types? Okay? And the answer is uniform. Every federal court that has addressed this question has said it is type, it is not specific. And I can give you.
I mean, I think that makes sense, because what is required is they're agreeing to do bad things through a pattern of interrelated racketeering activity.
Yes.
So.
Yeah, and so what we get to, and I mean, just to kind of illustrate it in a case like this, suppose you have members of a gang and they are discussing what they want to do versus their ops. And they say, we hate those guys. We want to kill them. Everybody agrees. Yeah, I mean, wherever they are, we're going to hunt down, we're going to kill them. If we can get them all, we'll get them all. We'll get as many as we can. Right? Have they agreed to kill a specific individual? You don't know the first person they're going to encounter. You don't know which of the members of the conspiracy will encounter that person first. If they are successful in encountering them, you don't know whether the encounter will be fatal to that individual, whether they'll be wounded, or whether they'll just be assaulted because somebody shot at them and missed. But all of those are acts of violence. All of those are within the scope of the enterprise. Mm-hmm. And in this case, you have all of those things actually happening in real life. They're not hypothetical. A terrorism analogy would be a group of people who agree to plant bombs. And they say, we need to destroy, I'll put it in Al-Qaeda type references. We're going to destroy the symbols of the great Satan's arrogance. Yes, what are those? His monuments, his hotels, his whatever. Okay. We must do this, yes. How far will we go? As many as we can do. They've agreed to make bombs, plant bombs, destroy things, hurt people. We don't know exactly which bomb will get planted, exactly where it'll actually go off, whether hundreds of people will be injured or nobody will be injured. But they have agreed to engage in this course of activity. That is the violation. It's manifest. In federal law, all they would have to have is that conversation. Georgia law, all they would have to do is have that conversation plus an email, a phone call, be many, many other things.
Mhm.
But that's all it is. And that's why, you know, and just for the record, I'll give you a few examples. United States v. Applins, APPLINS, 637 F 3rd 59 at 8081. The case held the jury was not required to answer special interrogatories as to which specific predicate acts each defendant would commit. U.S. versus Gutierrez.
What, 637 F what?
Sorry.
What's that one?
637 F 3rd 59
Okay.
at 8081. United States versus Gutierrez, GUYTERREZ, 963 F 3rd 320 at 328. District Court was asked to issue special verdict form requiring the jury to identify specific racketeering activities each appellant conspired to commit. It declined, affirmed.
Okay, is it reversible error to require the special interrogatory?
I could not say that. No. I don't think it's reversible error. I think I believe you have some discretion here.
Okay.
The question is, how is it best exercised under the circumstances? U.S. v. Cornell, spelled like the school, CORNELL, 780 F 3rd 616 at 625, 4th Circuit 2015. Cornell cataloged the cases and surveyed the federal cases and said I was quoting, every circuit to have considered this issue has concluded that for a Rico conspiracy charge, the jury need only be unanimous as to the types of racketeering acts that the defendants agreed to commit.
Okay, and that does seem to make sense to me because, again, we're at the conspiracy stage. We're not at the completed racketeering acts stage necessarily. So, okay. All right.
I won't belabor the point then.
What else? How about overt acts? I mean, those need to, if there's going to be one needs to be found, at least one needs to be found. That would need to be specified, right? And found unanimously, right?
At least they have to be unanimous that an overt act occurred. Yes. They generally, and I'm looking for, apologize, I have the link. I have an example. If I can't find it in 20 seconds, I will send it to you.
Okay.
But the instruction was you must unanimously find that an overt act was committed and you must be unanimous as to which one. It was not, you have to go top to bottom. And I think that is more efficient and just less likely to cause confusion. The overt act,
I would like
something
to
the statute requires, but it doesn't require a great deal of effort. Here, the question was, and I'll show you the case. It was not a Rico case. Unfortunately, lots of cases talk about what the court did, but don't tell you exactly what it said. They don't give you the exact instruction. A case called United States versus Boyle, B-O-Y-L-E, 96 F 3rd 1444. It is out of the Fifth Circuit. It was, I just want to be clear, it was not a Rico, it was a conspiracy.
Mm-hmm.
The question that was asked was, do you agree unanimously on at least one specific overt act which was committed in furtherance of the conspiracy to commit each of the offenses you checked in question one, because there was more than one conspiracy.
Yeah, I'm not sure how much we can say that's on all fours though, considering, like you said, it's a conspiracy case and not a Rico case, which I know Rico is not a conspiracy, but we've got a specific overt act requirement in our statute. Do you know of any Georgia case law or case law from a sister state with similar Rico statute that answers this question?
Well, I'll take a shot at that in a second. Let me back up, because the case I was talking about, I should have said this up front. It was conspiracy to commit obstruction of justice. The federal obstruction statutes don't have their own embedded conspiracy provisions. So that's a general 18 USC 371 conspiracy, which is almost identical to 1648. So that was under a conspiracy statute that had an overt act requirement, just like ours does. And if you were to match 1648 against 18 USC 371, basically the same statute. I think 1648 is drawn from 371.
Okay.
As far as other states addressing this, I have not found anything.
Okay, and so would your suggestion as to how the court ensures that they find one within the statute of limitations just be to include that in the instruction, not only you must unanimously find one and it must be unanimous as to which one it is, you must unanimously find one within whatever that date range is?
They have to find one within 5 years
Yeah,
of the indictment. That's the test.
But I mean, would you just say like, you must unanimously find one within this date range?
Yes, I mean, you could, well, the instruction that I saw, that's the other one I was going to talk about. And you suggested that you'd already settled that. I didn't hear exactly how it was settled,
Oh,
but the test,
yeah, the other one about like, I can't remember exactly what it said because I already deleted it from my version, but that anything that wasn't an overt act within that statute didn't even get included, and that's not true. It can be 500 of those as long as one of them is within the statute. They can find however many others they want to outside of the statute.
yeah, and they can go back to the beginning of time as well. This question was answered in a ruling by
Which
Judge
question
Landville. The statute of limitations question.
Yeah, I don't have any question about the statute of limitations.
Okay.
question.
All right.
I know that proposition was incorrect. And
Okay.
I understand what the law is.
All right. And then, okay, so I may have been missing the exact question you asked me.
So the question I asked is if I am not having them find, overt acts 1 through 190, do you find this or not?
Right.
Then is the way that I ensure myself that they found an overt act that is within the required 5 years prior to the indictment to just tell them you need to unanimously find at least one overt act within the date range and your decision about which one has to be unanimous?
Yes, I think that takes care of it. It actually answers both questions. Those were the only two charges I really had much to say about, and I think that would take care of it neatly.
Okay. All right. Well, again, we'll get into the nitty-gritty tomorrow.
Okay.
Okay.
For what it's worth, in Georgia, the closest that I know of this issue coming up was the Dorsey trial. And in that, Judge Becker had initially said she wanted the jury to fill out this form. That was a substantive Rico. And so she would have been listing predicate acts, not overt acts. But
Right.
It's kind of the same idea, basically. I don't know exactly why. And initially I wasn't successful in changing her mind, but she wanted to do it after they decided guilt or innocence and then bring the jury back. The jury went 3+ days and they came back. And
Well, there are these
were a mess.
federal statutes, or not statutes, I'm sorry, but there's federal case law that seems to suggest that they need to find guilt, and then, and only then, do they need to say what predicate acts they found, which I find to be odd, but.
That's mostly, I think, out of the Second Circuit, and nobody else has decided that they like it. I mean, you can find
that may have been
many
why,
different
but
ways of handling
yeah.
it, especially if you go back.
Very odd, doesn't help the jury at all.
Well, no, and asking the jury to do that if they've been deliberating for a very long time and coming back in and saying, and now you have another homework
I mean, what I want to do is give the jury, a logical and correct roadmap as to how do you consider this? What are you supposed to think about? What are you supposed to find? If you don't find it, then what happens? I want to give them instructions that actually help them deliberate.
Yeah. And it's actually, there are federal opinions that say sort of offhandedly, a RICO conspiracy case is a lot easier than a substantive one. I'm not sure everyone agrees with that. I don't think it's a lot more complicated. It's really, do you have an agreement? Would the agreement have violated the statute if it was consummated? And was there an overt act? And then as to each individual, were they part of that conspiracy or not? And if
All right, let me ask you this.
the nuts and bolts.
So there has to be a, determination from the jury, whether it's a violation of subsection A or subsection B, that, they conspired to either participate in the enterprise or acquire money through a pattern of racketeering activity, and that somebody committed an overt act to further just the criminal objectives of the conspiracy as alleged in the indictment, or to further the specific pattern of racketeering activity that had been agreed upon.
No, it is not. There's nothing, first to kind of walk it through, there's nothing in the case law that says it would have to be as specific as the second. And so if I'm just conspiring in an enterprise, if I'm just saying, I hear you guys are the best robbery crew in town, I want to be part of it. And they say, okay, but you have to ante up $1,000, or we have to use your car, pick anything you want. Give me your cell phone, lend me $100 till payday, any of that. As long as it ties to that enterprise, that's sufficient, and that's why the overt act itself doesn't have to be a crime. And part of what happens here is if we pile on additional requirements that aren't in the statute.
Okay, so it's just then to further the criminal objectives of the conspiracy. And it's the criminal objectives of the conspiracy as alleged in the indictment, right?
Yes. So
And
if
it's
I,
not the non-criminal objectives of the conspiracy, is it?
if I wrote a haiku that didn't talk about other gangs or violence or anything else, I don't think that would do it. I agree. But the point is, that overt act doesn't get mutated into a full-fledged attempt or conspiracy of its own.
Oh, yeah,
Because
I know.
otherwise the
I mean, it
statute
can
would say
be,
that.
we're gonna kidnap whomever,
Yeah,
and then we're gonna kidnap their daughter, or whatever. If I go by road, that's not illegal, but that's an overt act in furtherance of our conspiracy to do bad things.
you drive by the house and you say, yeah, they're home.
Yeah.
Okay? It's
Okay.
not illegal to drive by the house, it's not illegal to look in the window, but if it's part of that conspiracy,
Mhm.
yeah.
Yeah, but the objectives of the conspiracy, the objectives, so in the indictment, there are these objectives of the enterprise, YSL, listed out. Some of which
5, I think.
are criminal and some of which would not be criminal.
Some have non-criminal aspects to them, yes.
Some are entirely non-criminal. And so, an overt act to further one of those things would not equate to a crime, assuming all of the other elements are there,
I understand what you're saying.
right?
I think that's correct.
Legally correct?
It says, the statute says, an overt act to effect the object of the conspiracy. It speaks in the singular, it doesn't preclude
Right.
the plural.
And that has to be a criminal object, right?
We're talking about, well, the object is ultimately to violate a substantive provision. And I'm not trying to mince words, I'm thinking along with you.
Yeah,
But if you're forming an enterprise, remember that an enterprise can be legal.
yeah.
And so if I form an enterprise as part of this, different from this case, but an example, I form a corporation, but I'm forming the corporation as part of a securities fraud scheme or a money laundering scheme or something like that. That can be an overt act in furtherance of the objectives of the conspiracy is not itself illegal. I think we all agree the overt act itself doesn't have to be illegal.
Right.
The statute says to effect the object of the conspiracy.
Right, and when it says to effect the object of the conspiracy, implied in there, but necessary, is it has to be a criminal object of the conspiracy, because it wouldn't be a conspiracy if it weren't an agreement to do something criminal.
We wouldn't be charging a conspiracy to comply with the law. That's correct.
Okay.
Yeah.
All right. Anybody need any further exposition before we get more detailed tomorrow? Oh, absolutely. And if you want, I mean, it's only 4:20, so if you want to respond to anything right now, go ahead. But y'all wanted the afternoon to work on the directed verdict, so.
Reiterate my humble request of the state in an effort to get to the bottom of the directed verdict stuff and arguments. I know you're busy. Could someone please send over email copies of the exhibits that you have admitted? Because I think they were giving us, for most of the trial anyways, PowerPoints of the upcoming exhibits, and I think that would cut to the chase about a lot of these directed verdicts, because my memory is not perfect going back 8-9 months.
I believe Ms. Knight has started, and I thought she sent the link. I'm confirming. Are there certain acts that you want, because of the amount of media in some of them, they're taking a little longer? Are there certain acts, and we can talk about
Yeah.
certain acts that we can start with first, and then get to
Okay.
the other.
Okay.
And then y'all have specifically a list of evidence that exists and is admitted in this trial to support every one of these counts, right? Because I'm assuming, I mean, I don't know what they're gonna move for directed verdict on, but you'll have the answer as to whether there is evidence to support it. Okay.
And I'm just trying to.
All right, by tomorrow, when we take this up in the morning, like, I don't want you to say to me, oh, now that I've heard what the directed verdict is on, let me have the next 4 hours to get my response together. Because we talked about this a week and a half ago, that we were getting to this point and y'all needed to be ready with whatever y'all were gonna say as the defense and whatever you were gonna respond to as the state. Okay. All right, see y'all at, we wanna say 9? Okay, see y'all at 9.